Mr. President.
Senator from Alabama.
I would ask consent that the quorum call be dispensed with.
Without objection.
Mr. President, earlier today, my colleague, Senator Rubio, came to the floor to talk about the very serious matter of the nomination of Thomas Perez that will be before us, and specifically his refusal to comply with a bipartisan congressional subpoena into the investigation of his orchestration of a controversial quid pro quo with the city of St. Paul in a very important legal matter. Senator Rubio has talked about that ably and eloquently, and it's a very serious matter. I was in the Department of Justice for a number of years. I'm very uneasy about the way that matter was done. I don't believe that's normal business at all. In the course of his tenure, he has identified approximately 1,200, Mr. Perez has, personal emails that relate to his official duties and are responsive to the subpoena from the House, some of which reportedly disclose non-public information about publicly traded companies, yet he still refuses to turn them over to Congress, despite what appears to be a clear obligation to do so. The failure to comply with a subpoena is a very serious matter. A person wants to go from the Department of Justice, who issues subpoenas all the time and demands that people comply with them. Poor people, small businesses, whoever they issue a subpoena to, they expect them to be complied with. Congress has the ability to issue subpoenas. A member of the Department of Justice ought to respond to them. He has a high duty to respond to them, in my opinion. And I believe the Senate was incorrect in allowing his nomination to go forward to a full vote when we've not gotten the information that we have. The failure to vote for cloture and moving to a vote on a nomination is not a rejection of a nomination. Fundamentally, it's a statement, we're not ready to vote on it yet. We're not ready to have this matter brought before us because we need more information. He's not answering a subpoena issued to him by the House of Representatives. So I won't talk about that more, but I think it's a big deal. But that's not the first problem Mr. Perez has had in abusing the legal process. I want to share a few thoughts about some others, frankly. I hate to do this. I was concerned about the nomination, and when he came forward, I met with Mr. Perez at some length. Senator Tom Coburn and I did, and I came away uneasy about it. I had a feeling that his ideological political agenda was so strong and his legal commitment was not strong enough, and that he would use this position in the Department of Justice to advance an agenda rather than enforce the law. And I'm afraid that's what's happened. Many of my colleagues will recall that on Election Day in 2008, 3 members of the new Black Panther Party stood at the entrance to a polling station in Philadelphia, brandishing nightsticks and threatening voters. What more intimidation can you have than that at the voting place? They wore military-style uniforms, combat boots, battle dress pants, military-style insignia, and used racial slurs and insults to scare away would-be voters. One of the men was Jerry Jackson, a member of Philadelphia's 14th Ward Democratic Committee and a credentialed poll watcher for the Democratic Party on Election Day. Now, this is not acceptable. This is clearly voter intimidation, dramatic voter intimidation. A video of the incident was widely distributed on the Internet, made national news and headlines. The Justice Department under the Bush administration secured an affidavit from Bartle Bull, a longtime civil rights activist, former aide to Robert F. Kennedy. in his 1968 presidential campaign. Mr. Bull called the conduct, quote, an outrageous affront to American democracy and the rights of voters to participate in an election without fear, close quote. None of the defendants in the case even filed a response to the complaint against them or appeared in the federal district court in Philadelphia to answer the lawsuit. Maybe they didn't feel like they had a defense. And it appeared almost certain that the Justice Department would have prevailed in their case. But according to a May 2009 article in the Washington Times, the Justice Department had been working on the case for months and had already secured a default judgment against the defendants by April 20th of 2009, 3 months after President Obama took office. However, President Obama's political appointee, Mr. Thomas Pirelli, then acting head of the Civil Rights Division, overruled career prosecutors and voluntarily dismissed the charges against 2 of the men with no penalty and obtained an order against the 3rd merely prohibiting him, get this, prohibiting him from bringing a weapon to the polling place in future elections, which was already against the law. What a sad end of that case. To me, it's just unthinkable. But in a 2009 memo, career appellate chief, career attorney in the Department of Justice, chief of appellate division, Diana K. Flynn, wrote that the Justice Department could have made, quote, a reasonable argument in favor of default relief against all defendants and probably should, close quote. That's what the career attorney said about the matter. Well, the Justice Department's highly unusual dismissal of the case of a dramatic voter intimidation was the subject of a year-long investigation by the United States Commission on Civil Rights. This is an independent commission that's set up by our government, has appointees from both parties, and they are focused on ensuring that civil rights are protected. And they were trying to examine how it was this case was handled in this fashion. On April 1st, 2010, Chairman Gerald Reynolds sent a letter to the Attorney General Holder asking whether the Department of Justice would fully cooperate with the Civil Rights Commission's investigation and allow 2 department attorneys to testify in their investigation. The letter also pointed out that the department failed to turn over requested documents. The commission had asked for requested documents. They have a right to do that. According to Civil Rights Commissioner Peter Kirsanow, in total, the Civil Rights Division of the Department of Justice refused to answer 18 separate interrogatories, refused to provide witness statements for 12 key witnesses, refused to respond to 22 requests for production of documents, refused to produce a privilege log. This in spite of the fact that the Justice Department has a statutory obligation to fully comply with the U.S. Commission on Civil Rights in their investigations. They think they're above the law now in the Department of Justice? I got to tell you, I spent 15 years in the Department of Justice. I love the Department of Justice. And I've never seen some of the things that have happened in recent years. And I believe the public needs to know more about it. I've tried not to be too critical and Attorney General Holder and haven't. But I'm concerned about this. So later, 2 attorneys in the Department of Justice defied the department and actually agreed to testify against the department's recommendation before the Commission on Civil Rights at considerable risk of their careers. J. Christian Adams and Christopher Coates, the former chief of the Voting Rights Section. Mr. Coates was the former chief of the Voting Rights Section. Adams and Coates stated that, quote, political appointees declined to prosecute the new Black Panther case because they were interested only in civil rights cases that involved equality for racial and ethnic minorities and would not prosecute civil rights cases in a race-neutral way. Adams called the actions in the new Black Panther case. This is what the attorney in the Department of Justice said about the case. He was involved in it. Quote, the simplest and most obvious violation of federal law, close quote. That he had ever seen in his career at the Justice Department. And he resigned as a result of the dismissal of the obviously justified case. In his sworn testimony before the commission regarding Mr. In his sworn testimony before the commission, Mr. Perez unequivocally denied the allegations. Commissioner Peter Kirsanow asked him this question, quote, was there any political leadership involved in the decision not to pursue this particular case any further than it was? Answer, Mr. Perez, no. The decisions were made by Justice Department career attorneys, Loretta King, in consultation with Steve Rosenbaum, who is the acting Deputy Assistant Attorney General, Mr. Perez said. In a recent letter to members of the Senate regarding Mr. Perez's nomination, Commissioner Kirsanow stated this. He said that Mr. Perez's testimony, quote, should be of tremendous concern to all senators regardless of party, close quote. Indeed it should. In fact, it was not until a Freedom of Information Act lawsuit filed by Judicial Watch that the Justice Department finally produced a privileged log identifying more than 50 emails between high-level Justice Department political appointees and career attorneys regarding the government's, quote, decision-making process, close quote, in this case, all around the time of the Department's otherwise bewildering decision to drop a case it had already won by default. Judge Reggie Walton, African-American federal judge in D.C. here of the U.S. District Court for the District of Columbia, stated in his opinion that the internal documents, quote, appear to contradict Assistant Attorney General Perez's testimony that political leadership was not involved, close quote. Let me repeat that. This is a federal judge in the District of Columbia, quote, that the internal documents, quote, appear to contradict Assistant Attorney General Perez's testimony that political leadership was not involved, close quote. Indeed it does. You've got a federal judge finding this as in his opinion. And Judge Walton further said, quote, surely the public has an interest in documents that cast doubt on the accuracy of government officials, close quote. He was referring to the fact that they weren't producing documents and that the public was entitled to have documents that cast doubt on the accuracy of the testimony of government officials. And he says, quote, representations regarding the possible politicalization of the agency decision-making, close quote. Mr. Walton himself at one time was in the Department of Justice. I'm sure he has a high opinion of the Department of Justice. He's not trying to abuse them. He's just saying he has Department of Justice officials have an obligation to tell the truth, and if they don't, they ought to be found out about it. So the handling of the case was so extraordinary that the Justice Department's Inspector General, appointed by President Obama, initiated an investigation of the matter. The Inspector General's report confirmed testimony of Mr. Adams and Mr. Coates, and importantly, it concluded this, quote, Perez's testimony did not reflect the entire story regarding the involvement of political appointees in the new Black Panther decision-making. In particular, Perez's characterizations omitted that political appointees, Associate Attorney General Pirelli and Deputy Associate Attorney General Hirsch, were involved in consultations about the decision as shown in testimony and contemporaneous emails. Specifically, they set clear outer limits on what career attorneys could decide on the matter, including prohibiting them from dismissing the case in its entirety without seeking additional approval from the Office of the Associate Attorney General. So the Department's own Inspector General looked at the matter and concluded that Mr. Perez's testimony that the political appointees didn't have anything to do with it. It was all career attorneys that decided on the merits not to prosecute this case, was not accurate. And he went on to explain why. So this isn't a House committee having a hearing on it. This is the Inspector General of the Department of Justice, an Inspector General basically appointed by President Obama and selected by the Attorney General himself. And basically the political appointees put a fence around the case and said you can't take any real action on it until we get our approval. So now in his interview, Mr. Perez said he did not believe these incidents constituted political appointees being involved in the decision. Give me a break. We believe these facts evidence involvement in, well, let me go back and get this precisely correct. This was the Inspector General's report. Quote, Inspector General found, quote, in his interview, Perez said he did not believe these incidents that I just mentioned constituted political appointees being involved in the decision. We believe these facts evidence involvement in the decision by political appointees within the ordinary meaning of that word, and that Perez's acknowledgment in his statements on behalf of the Department that political appointees were briefed and could have overruled his decision did not capture the full extent of that involvement, close quote. That's what the Inspector General said. So to me, that sounds like a bureaucratic way of saying Mr. Perez did not tell the truth to the Inspector General during the course of an official investigation of his conduct. So now we're going to promote him? Apparently that's what goes on around here. True, the original decision to dismiss the case predated Mr. Perez's appointment to the Civil Rights Division. He was not there at that time. That is true. But instead of reinstating the case, which would have been the correct decision, he became directly involved in and managed, according to the Inspector General, what in fact was a cover-up of the processes that occurred. That in and of itself should disqualify him for this position. I mean, this is not good. To be found by your own Inspector General in the United States Department of Justice, to not respond truthfully, to have a federal judge find that, to have the own Inspector General find that. This is not, we're getting far too blasé about officials and high officials in this government not telling the truth. He should not be rewarded with promotion for his work protecting political appointees in the Department of Justice. The Inspector General report also confirmed that Mr. Perez has overseen most of the unprecedented racial polarization and politicalization of the Department of Justice Civil Rights Division. There's just been a lot of turmoil there over it. The disagreement about what the right thing to do is, but there's been a consistent theme of his, which is to advance a certain political and ideological agenda, it seems to me. And I'll just explain what I mean. I want to be fair to him, but I'm I've been around a lot of litigation for a long time, and I'm not comfortable with his actions. So he has sued states for implementing voter identification laws, sued the states for that, which has been rejected by federal courts to intimidate them and stop them from saying you have to have an identification of some kind before you're allowed to walk in and say you're John Jones and you're entitled to vote. What if you're not John Jones? States have passed laws like that. The federal court has rejected his view, including a 3-judge panel on the United States District Court for the District of Columbia in Washington, including Judge Colleen Kohler-Catelli, who was a Clinton appointee. And Mr. Perez's arguments have been rebuked by courts in Arkansas about the Civil Rights for Institutionalized Persons Act, in New York in an education case, U.S. versus Brennan, in a Florida case where Perez's team was abusively prosecuting peaceful pro-life protesters, and in a major loss in court in Florida when he was trying to force the state not to remove non-citizens from the voter rolls. Apparently Florida, in his mind, was violating civil rights by saying non-voters, non-citizens shouldn't be on the voting rolls. Is this who's running the Department of Justice? Is this the philosophy they're having in Washington? So the department has filed and is considering lawsuits against a growing list of states that have enacted immigration legislation, including Alabama, Arizona, Utah, Indiana, Georgia, and South Carolina. Although Mr. Perez was not involved in the department's lawsuit against Alabama, my state, he's issued threats and engaged in intimidating tactics against Alabama law enforcement officials who've reported to me shock at the nature of those events. For example, he took the unprecedented action of creating a toll-free hotline for people to report allegations of discrimination due to Alabama's immigration law, although Attorney General of Alabama, who said, I'll prosecute anybody who violates people's right to vote. Mr. Strange said, tell me who's made complaints that you say have made complaints about not being treated fairly, and I'll investigate it. Mr. Perez said there were bullying and harassment complaints out there, but when asked to produce some of them, he's refused to provide it. Alabama officials are questioning whether the reports of complaints were in fact true. They won't say what they are. On October of 2011, Ms. Perez sent a letter to the superintendent of every school district in Alabama requesting the names of all students who withdrawn from school and the date without any apparent authority to do so. He just wanted to snoop into that, I guess. In December of 2011, he sent a letter to all Alabama sheriffs and police departments that received federal funds, many of them through the Department of Justice, where he was, warning them, I think without basis, not to infringe on constitutional rights in enforcing Alabama's immigration law. There's no proof anybody had violated constitutional rights in enforcing that law. Mr. Perez actually threatened to withdraw federal funding from any of the 156 offices that implement, quote, the law in a manner that has the purpose of or effect of discriminating against the Latino or any other community, close quote. He also warned that the Civil Rights Division is, quote, closely monitoring the impact of the law, close quote. On January 20th, Mr. Perez met in Tuscaloosa with Tuscaloosa County Sheriff Ted Sexton, who previously has held a high public safety office in the federal government in Washington, and several other sheriffs around the country. Sheriff Sexton told Mr. Perez that he perceived his letter as a threat and asked him whether he should expect any lawsuits against him or any other law enforcement officials. And Mr. Perez wouldn't comment. Sheriff Sexton also pressed for examples of the reports of discrimination in Alabama that Mr. Perez had purportedly received, but he again refused to comment or provide evidence. According to Sheriff Sexton, a sheriff from Georgia was present and asked another Justice Department representative who was present with Mr. Perez whether states like Alabama and Georgia were being penalized for the sins of our grandfathers, and the official reportedly responded, "More than likely." I received a letter from Sheriff Huey Mack in Baldwin County, a fine sheriff who responded after 9/11 to New York and did forensic work there. And Sheriff Mack states in opposition to this nomination, quote, "Following the issuance of this letter, several law enforcement officers met with Mr. Perez in Mobile, Alabama. During this meeting, Mr. Perez made several false allegations relating to law enforcement's handling of Alabama's immigration law. This continued for a short period of time, during which it became evident Mr. Perez was not interested in the truth, but wanted to rely strictly upon his biased and preconceived notions regarding the state of Alabama. Mr. Perez should not be confirmed to any cabinet-level post. In my opinion, Mr. Perez should be relieved of all his duties as it relates to the United States federal government and seek employment outside of serving the citizens of this nation," close quote. Well, I wasn't there, but I know Sheriff Mack, and something really was wrong for him to write such a strong letter. And Sheriff Sexton was at another meeting that he's referring to. A very able sheriff. When Mr. Perez was nominated to lead the Civil Rights Division, I had serious concerns about whether he would work to protect the civil rights of all Americans regardless of race, and whether he would ensure that the division remained free from partisanship and not be used as a tool to further an agenda or some ideology. These concerns had a basis, in fact, from looking at his prior record. That was the concern that I had. When he ran for Montgomery County, Maryland Council, he responded to a question asking, "What would you like the voters to know about you with?" Quote, "I am a progressive Democrat, always was and always will be," close quote. Well, you know, that's okay, but when you get to be in the Department of Justice, you have to put that aside. So I asked him about that in our meetings. In an April 3rd, 2005 Washington Post article, he was described as, quote, "about as liberal as a Democrat can get," close quote. Well, there's nothing wrong with that. But you got to be able to put it aside if you're going to serve in the U.S. Department of Justice. As a councilman, he expressed disdain for Republicans at one point, giving, quote, a 5-minute speech about how some conservative Republicans do not care about the poor, close quote. Well, that's his opinion, but it shouldn't infect his duties as an official in the Department of Justice. From 1995 to 2002, while employed as an attorney in the Civil Rights Division, he served on the board of CASA de Maryland. He later became president of that organization. CASA, which is actually an acronym for Central American Solidarity Association, is an advocacy organization with some extreme views, funded in part by George Soros, that opposes enforcement of immigration laws. I mean, they're just flat out there active about it. From the Department of Justice, you need somebody who favors enforcing the law, not enforcing the law. What are the prosecutors supposed to do in the Department of Justice? Undermine law or enforce law? When I was in the Department of Justice, we understood our job was to enforce the law, not make it. For example, this Casa Maryland group issued a pamphlet encouraging illegal aliens not to speak to police officers or immigration agents. It promoted day labor sites. That's where illegal workers go out and get jobs. So they promoted that. It had fought restrictions on illegal immigrants receiving driver's license, and it supported in-state tuition for illegal immigrants. So this is the organization he was president of. And I talked to him about that, and I was not convinced that he could set that aside when he became official in the Department of Justice, who would be required to enforce those kind of laws passed by the Congress and states. So Mr. Perez has spoken in favor of measures that would assist illegal aliens in skirting immigration laws, and while a councilman in 2003, he supported the use of the matricular consular ID cards issued by Mexico and Guatemala as a valid form of identification for local residents who worked and used government services without having any U.S.-issued documents to prove they were lawfully here. Notably, no major bank in Mexico accepts these identification documents. They're not a valid identification document. Unfortunately, so my initial concerns about Mr. Perez's nomination have been confirmed. I hate to say that I don't feel like, and I have to say I don't doubt that he will continue, if confirmed, as the Secretary of Labor, to do all that he can within his power to hamstring enforcement of immigration laws and to advance his political agenda. That's what his background is. That's what he's done, as I've documented here. His misleading testimony before the U.S. Civil Rights Commission, as Mr. Kirsanow pointed out, the veracity of which was questioned by a United States federal judge here in District of Columbia, his false statements to the Inspector General of the Department of Justice, and who wrote about it in his analysis and report on the incidents, his refusal to comply with a congressional subpoena by the House of Representatives, and really his abysmal record at the Department of Justice disqualifies him, in my view, for this position. And frankly, we should not have closed debate on his nomination and moved it forward until we got the information that's out there. What if this information is produced next month and it's very, very incriminating or unacceptable? We're going to then ask him to quit? That's not the way you should do business here. We have hearings. We ask questions of nominees. And if they don't answer questions, normally they don't move to the floor for confirmation. So I think this is a legitimate concern that the American people ought to know about. I believe the American people have a right to know all the information about Mr. Perez's tenure in office, the criticisms of a very serious nature that he has received, and the fact that he seems to have a strong bent toward allowing his own ideological and political views to infect his decision-making process, all of which is unacceptable for a high position in this government of the United States of America. I would appreciate the Chair's indulgence and would yield the floor.
Mr. President.
Senator from Connecticut.
Mr. President, I rise today to speak in support of the nomination of Gina McCarthy to be this nation's next EPA administrator. Mr. President, you and I know Gina McCarthy's work firsthand because prior to joining the EPA, she was our commissioner in the state of Connecticut of the Department of Environmental Protection, where she served under a Republican governor, worked with both parties to advance the environmental and business interests of the state. And so first, I want to very briefly share with my colleagues why I support Gina McCarthy. But then I frankly want to talk about why I believe that my Republican colleagues who may not be supportive every single day of the year of the mission of the EPA should support her as well. I support Gina McCarthy because for her entire career she has been a champion of public health. A lot of people who rise to lead federal agencies, they spend the majority of their career here in Washington, and there's nothing wrong with that, but there is something special that comes with somebody like Gina McCarthy, who started her career as a local public health official in Canton, Massachusetts. She learned public health at the ground level, and she understood very early on that the government working together with the business community can have an enormously positive effect on the health of our nation. I support her because she's come up the right way through the grassroots of America's public health infrastructure. I support her because of the great work that she did in Connecticut when she was, as I mentioned, our Republican-appointed Commissioner of the Department of Environmental Protection. One of the things she did was work with states all throughout the Northeast on something called RGGI, which is a voluntary association of states throughout the Northeast region to try to reduce carbon emissions. There is nothing but success when you tell the story of RGGI. She did this under a Republican governor. There are a number of Republican governors, along with Democrats, who participated in this plan. But over time, the plan was to reduce carbon emissions from northeastern states by 10%, moving towards 2018. But through this mechanism, what we have seen is not just a reduction in carbon emissions from Connecticut and the states that participate, but a pretty amazing reduction in the amount that ratepayers are paying. Why? Because through this rather modest cap-and-trade regime, we were able to take the money gleaned through the system and put it right back into efficiencies so that ratepayers were paying less. So much so that the estimates are that consumer bills will be $1.1 billion less because of the work that Gina McCarthy did. It's an average of about $25 off the bill of a residential homeowner and about $181 off the bill of commercial consumers. And I support her because of what she's done since she's come to the EPA, leading the air quality initiatives at the EPA. She's just made a huge difference. You take a look at just the mercury and air toxins rule alone, and the estimates are almost hard to comprehend. 11,000 premature deaths will be prevented because of the work that she did. Just on that one effort alone, 4,700 heart attacks will be prevented because of these toxins disappearing from our air. And, you know, maybe most importantly to those of us with little kids at home, 130,000 asthma attacks won't happen in this country, largely to children, because we'll have cleaner air to breathe. I support Gina McCarthy because of the work that she's done her entire career to be a great steward of the environment and a resolute champion of clean air. But I want to talk for just a few minutes about why I think our Republican colleagues should support her as well. You know, we had a breakthrough this week on the issue of how this body will treat at least this set of nominees. And I think there was agreement between Republicans and Democrats that the president of whatever party he may be, he or she should get his or her team in place, and that this body should work to make sure that that occurs. And maybe with the one caveat that there should be a responsibility of the president to put people with a pragmatic mind in charge of agencies that might be ones in which there's disagreement here over their mission. I might not expect my Republican colleagues to support somebody going to the CFPB or to the EPA that is just a rigid ideologue. But I think there is agreement that if the President does choose a pragmatist, somebody that is willing to reach out across the aisle, that is willing to build coalitions, then this body should support the President's team. And I want to make the case to my Republican colleagues as they make their final decision as to how they're going to vote on Gina McCarthy. That is exactly who she is. You know, lots has been made of the fact that she really, with the exception of her appointment to the EPA during her tenure under President Obama, has been a Republican appointee. It wasn't just Governor Jody Rell, a Republican that I disagreed with on a lot of things back in Connecticut, that appointed her to head up our DEP, but she also, of course, got her start in the higher ranks of environmental protection from Mitt Romney in Massachusetts. And so she has clearly demonstrated that she's someone that is able to work across the aisle. But what I think Republicans want to know is, as she presides over an EPA that is going to move forward with new regulations for proposed power plants, and we hope will move ahead with new clean air regulations for existing power plants, is she going to do that in a rigid arbitration, or is she going to be willing to listen to industry as well? And so I want to just give you a couple quotes that come from people that work in the industry, people, frankly, that I don't agree with, that the President doesn't agree with, and frankly that Gina McCarthy isn't going to agree with all the time, but people who have worked with her who have, at worst, a begrudging respect for the work that she's done, and at best, frankly, an admiration. William Bumpers, who's a partner at a law firm in town who represents power plants and other industry clients, says, quote, Gina McCarthy is one of these avid environmental program managers who is exceptionally competent but practical. My experience with her in the past 4 years, I can meet with her. She's very forthright. There's no guile with her. While I haven't always agreed with the rules that come out of there, there's never been any guesswork about what comes out of there. Gloria Berquist, who's the Vice President of the Alliance of Automobile Manufacturers, says she is a pragmatic policymaker. She has aspirational environmental goals, but she accepts real-world economics. Charles Warren, who was a top EPA official in the Reagan administration, who now represents a lot of people in the industry, says, at EPA as a regulator, you're always asking people to do the things they don't want to do. But Gina, she's made an effort to reach out to industries while they're developing regulations. She's got a good reputation. And even the spokesman for the National Mining Association, this might come under the category of grudging respect, but he says she is very knowledgeable. I don't think anyone is questioning her understanding or ability. She will not be caught off guard in any defense of what they have done. I expect her to be well informed. She just doesn't strike me as an ideologue. This is what the industry says. We know that Republicans support her because that's how she got the jobs that led to her position at the EPA. But even within industry, they recognize that they are going to disagree with her. They are not going to come down to the EPA in a parade of support for some of the things that she may do, but they acknowledge that she's going to listen and that to the extent possible she's going to work with them. And I think that's who we want at the EPA. And I think that's who Gina McCarthy will be. And I don't think that just because of speculation. I think that because, as the junior senator from Connecticut, I watched her walk the walk and talk the talk in Connecticut. I know that she did it in Massachusetts because that's why we picked her in Connecticut, and I've certainly seen her do it in her years heading clean air policy at the EPA. For my friends who want a strong, passionate advocate for clean air, you got one in Gina McCarthy. And for my friends who want a pragmatist who, though they may disagree with, is going to at least be practical in how she implements the policies of this administration, you have that voice too. Gina McCarthy will be a great pick at the EPA, and I urge my colleagues to support her. Mr. President, I yield back the floor.
Senator from Rhode Island.
Thank you, Mr. President. It's a pleasure to see both senators from Connecticut here, one speaking and one presiding, and to reflect on the junior senator's comments about the EPA nominee, Gina McCarthy, who has not only worked in Connecticut but in Massachusetts. So she has surrounded my state of Rhode Island, and we've had plenty of, I would say, indirect exposure to her, and I think she is terrific, and I could not agree more with the senator's comments, and I look forward to a swift confirmation for her to get to work rapidly on the issue that brings me to the floor again for the 39th time, which is to try to get this body to wake up to the threat of climate change. Speaking of Massachusetts, I'll also welcome our new senator from Massachusetts, my New England neighbor, Ed Markey. For decades, Ed has been a passionate leader in Congress on energy and environmental issues. He's been a true champion on climate change, and he and I serve as co-chairs of the bicameral task force on climate change, along with our colleagues Representative Waxman and Senator Cardin. So I really look forward to continuing to work alongside now Senator Markey to forge common-sense solutions to the crisis of climate change. We need common sense in a place where the barricade of special interest influence has blocked action on climate change, and where even the debate itself is polluted with falsehood and fallacy and fantasy. Look no farther than the Republican response to the announcement last month of President Obama's National Climate Action Plan. The President described in his speech some of the overwhelming evidence that our planet is changing. The 12 warmest years in recorded history have all come in the last 15 years, he said. Last year, temperatures in some areas of the ocean reached record highs, and ice in the Arctic sank to its smallest size on record, faster than most models had predicted it would. These are the facts. That's what the President said. Here in the Senate, the President's facts were challenged. Those aren't the facts, Mr. President, flatly replied one of my Republican colleagues. It's not even true. So let's look. Where were the facts and where the falsehood? Well, according to NASA, the President had the facts right on warming. Indeed, he may actually have understated the severity of global warming. In fact, the 13 hottest years on record, the red ones, have all occurred in the last 15 years. The 13 hottest years on record have all been in the last 15 years. And I remind my colleagues that NASA is the organization that right now is driving a rover around on Mars. We might want to consider that these are scientists who know what they're talking about. As to ocean temperatures, the other part of the President's assertion, NOAA says, and I quote, sea surface temperatures in the Northeast Shelf large marine ecosystem during 2012 were the highest recorded in 150 years. The President's facts were right again. And this chart from the National Snow and Ice Data Center at the University of Colorado shows, just as the President said, the 2012 yearly sea ice melt in the Arctic smashed previous records. Furthermore, the data center confirms that, and I'll quote them again, ice extent has declined faster than the models predicted. So, in the contest between fact and falsehood, the President was completely accurate on his facts. And facts, as John Adams said, are stubborn things. not to be easily brushed aside for convenient falsehoods. So falsehoods, fallacies, and fantasies. Let's go on to a fallacy. My Senate colleague warned against accepting what he called, I'll quote, the extreme position of saying that carbon dioxide is the cause of climate change or of global warming. And he suggested that carbon dioxide can't be a threat because it's found in nature. We exhale it. Well, that's a fallacy, an incorrect argument in logic and rhetoric resulting in a lack of validity or, more generally, a lack of soundness. That's the definition of a fallacy. Arsenic is found in nature, but in the wrong concentration and in the wrong places, it is nevertheless still dangerous. And the principle that carbon dioxide warms the atmosphere dates back to the time of the American Civil War. It is not late-breaking news. It is sound, solid, established science. Quite simply, the position that carbon dioxide isn't causing climate change is the extreme one. The overwhelming majority of climate scientists, at least 95% of them, accept that global climate change is driven by the carbon pollution caused by our human activity. We're having a hearing this week on climate change in the Environment and Public Works Committee. Even the witnesses invited by the minority to that EPW hearing acknowledge the effects of carbon on our climate. In a recent interview, minority witness Dr. Roy Spencer of the University of Alabama, Huntsville said, and I'll quote him, "I don't deny that there has been warming. In fact, I don't even deny that some of the warming is due to mankind." In another interview, he said, "I'm one of those scientists that think adding carbon dioxide to the atmosphere should cause some amount of warming. The question is how much?" Another minority witness, Dr. Roger Pelkey of the University of Colorado, testified before the House Committee on Government Reform back in 2006. Here's what he said. "Human-caused climate change is real and requires attention by policymakers to both mitigation and adaptation." He went on to say, "There is no quick fix. The issue will be with us for decades and longer." These are statements by the witnesses invited by the Republican side. It is simply not credible any longer to just deny climate change. The view that carbon emissions have caused climate change is shared by virtually every major scientific organization, from the American Association for the Advancement of Science to the American Geophysical Union to the American Meteorological Society. But of course, to the polluters, this isn't about the facts. It's about political power. They bought this clout, and they're going to use it. Facts be damned. The Republican response to the President's climate plan even served up the old ClimateGate fantasy. That's the faux scandal in which hacked emails between climate scientists were selectively quoted to try and throw doubt on years of peer-reviewed research. The scientists, my colleague said, quote, "were exposed for lying about the science for all those years," end quote. Nothing of the kind is true. None of it. 8 groups, because of the kerfuffle about this, 8 groups, including the Office of the Inspector General of the U.S. Department of Commerce and the National Science Foundation, reviewed those whipped-up allegations against the researchers and found no evidence of fraud. None. Turns out the so-called ClimateGate scandal is pure fantasy. But even that fantasy flies in low orbit compared to the high-flying Republican fantasies about what regulating carbon pollution would do. Again, according to my colleague, putting a price on carbon pollution will cost, and I quote, about $3,000 a year for each taxpayer. There's some history here. This scary, misleading number has been kicked around by Republicans since 2009. As the colleague noted, the $3,000 per year figure is derived from a 2007 MIT assessment of cap and trade proposals. But there's more. When PolitiFact asked one of the study's authors what he thought of the Republicans' characterization of his work, here's what he said: "It's just wrong. It's wrong in so many ways, it's hard to begin." That is the assertion that's being quoted on the Senate floor, one that is wrong, according to the authors, wrong in so many ways, it's hard to begin. PolitiFact rates political statements, generally from true to false, but it reserves a special designation for fantasies. PolitiFact, all the way back in 2009, gave these comments that very special designation, pants on fire. The fact, according to the nonpartisan Congressional Budget Office, is that the cap-and-trade bill's actual costs were modest, about 48 cents per household per day. And further, it's worth noting that these environmental rules, like the Clean Air Act, let's use that as an example, actually save money overall. In the case of the Clean Air Act, it's been documented. $40 saved for every $1 spent. 40-to-1 return on the cost of the Clean Air Act for the benefit of all of us. Just as fantastical are our colleagues' claim that new Environmental Protection Agency greenhouse gas regulations would cover, I quote, every apartment building, churches, and every school. And here's another good one. I'll quote, that EPA will need to hire 230,000 additional employees and spend an additional $21 billion to implement its greenhouse gas regime. That may be true in Fantasyland, but in reality, EPA has specifically issued a rule limiting the regulation of greenhouse gases to only the largest sources, such as power plants, refineries, and other large industrial plants, while exempting smaller sources like restaurants or schools and other small buildings. In fact, EPA filed a court brief, a signed court brief, a representation to the courts of the United States that regulating every apartment building, churches, and every school, as my colleague put it, is wholly unrealistic. By the way, EPA has fewer than 18,000 employees. It has fewer than 18,000 employees. To add 230,000 new employees, it would have to increase its workforce by 1,300%. Really? If EPA had 230,000 employees, it would be equivalent to the 20th largest corporation in the United States. It would be larger than General Motors and Walgreens. And in fact, back here on Earth, this claim has been evaluated when it was made by other Republicans by PolitiFact. And those similar statements received a rating of false. Mr. President, I applaud the President for courageously taking the lead on protecting the American people and the American economy from the devastating effects of carbon pollution on our oceans and our atmosphere. I hope that my Republican colleagues would consider the differences between the administration's regulatory approach and the market-based solutions we could implement through bipartisan legislation. I hope that they will decide if they're content to holler from the back seat about this or whether they're willing to come forward and join with us, put hands on the wheel, and design common-sense solutions for a very real problem. Unfortunately, instead of seizing this opportunity, the other side of this debate can't let go of the falsehood and the fallacy and the fantasy. We were together the other night, Monday night, as a Senate. We joined together. We went to the old Senate chamber to discuss a lot of issues relating to the filibuster and to the Senate, and a lot of high-minded things were said that Monday night. A lot of good things about the traditions and the institution of the Senate. Well, traditions of the Senate worth preserving include that we don't traffic in falsehoods, in fallacies, and in pants-on-fire fantasies. That we face even unpleasant facts squarely. That's our job. And that we do our job. We have received credible and convincing warnings. We have received compelling calls to act. The denial position has shown itself to be nonsense, a sham. It is time to wake up. And for us to do the work necessary to hold back, to mitigate, and to adapt for the climate change that our carbon pollution is causing. And yet, we sleepwalk on in this chamber. We sleepwalk on in Congress. Well, it's time to shelve the falsehood, fallacy, and fantasy and have an honest discussion here about how we're going to address the very real threat of climate change. Mr. President, it is time to wake up. I yield the floor. And I'll note the absence of a quorum.
Clerk will call the roll.